Hello, founder. You've built a successful business, and now it's time to think about that once in a lifetime exit from your business. You've come to the right place. Here, you will hear business exit professionals involved in the buying and selling of companies talk about what you should know before you exit. If you've never sold a business before, this podcast can be super helpful to you. I'm Armando, host of the Founder's Guidepost. Enjoy. If you like this information, please subscribe and share. Hi, Armando Rahman here with the Founder's Guidepost. Here today with Sandra Etherton, intellectual property attorney. Sandra, how are you?
I'm great. Thank you. Thank you. It's an honor to be on your podcast. Appreciate the invitation. Yeah.
I'm excited to have this conversation because, as you and I talked before, so many people just don't really understand how to lock down what they have. They developed great companies, great businesses, and they have all the value in different places. Part of it is their intellectual property. And speaking with someone like you who really understands that space can help them secure it and keep it safe and hold on to that value is just so critical, especially when it's time to transition themselves out of the business and get that business into somebody else's hands, whether it's their adult son, adult daughter, or a private equity firm, whatever. So, Sandra, you are an intellectual property attorney, obviously known you, I don't know, probably over 20 years now.
Yes.
We met through a local nonprofit. That's how I learned of you as an IP attorney. And so I'd like you, if you could, just to describe in general, what is intellectual property?
Sure. Well, again, Armando, thank you very much for having me on your podcast. I've been an intellectual property attorney for over 25 years, representing exclusively privately held companies from startup through exit. So your listeners today are right up my alley, and I'm looking forward to kind of giving an outline of intellectual property. So intellectual property is an umbrella term for intangible assets, not physical assets. And in fact, sometimes intellectual property is referred to as intangible property. And you'll also hear intellectual property referred to in shorthand as IP. Intellectual property includes things like your brand, the products that you've developed, internal processes for how you run your business, internal financial information, people information, licenses for domain names and social media accounts. So, it's pretty much anything that is intangible that has value to your business. And, when a founder exits the business, there's not only the physical assets and the cash flow, but the business is also valued on intangible assets. And, acquirers, investors look for what that intellectual property is. And so in order to know what it is, you have to identify it and hopefully protect it. And if you've identified it, you hopefully can attach a value to it, which adds to, of course, the other value of your physical assets. But if you can't list them, you can't value them. And so in essence, they have zero value. So it's important for business owners to identify their intellectual property and protect it to increase the value of their business to the subsequent owners.
Wow. So intellectual property, I'm thinking of the apple with the bite out of it.
Oh, yes. The logo, the Apple logo.
Exactly. And that's probably one of the most common, maybe Coca-Cola, another very common one that people know across the world. I did a little homework and saw somewhere that Apple logo, who knows till it's actually sold, but the Apple logo itself, because of what it represents, is worth about $2 billion.
Yes. Yeah. Your trademark is one intellectual property asset of your business. And the good thing about trademarks is that all businesses have them. So for those business owners who think I don't have any intellectual property, well, sure you do. You at least have your company name, which is going to function as a trademark, and maybe you have a logo as well, maybe some taglines. And hopefully, the business owner has taken affirmative steps to protect it. I mean, all businesses have intellectual property. Whether they've identified it and protected it is a different thing. And I find that there's a spectrum of business owners. There's the ones on one end that they're very modest. They don't even think they have any intellectual property, and so they haven't taken any steps to protect it. And there's another kind of business owner at that end that thinks maybe, I don't know what IP is, I don't know who to ask, or it's too expensive. And then you've got, businesses, the majority of businesses have done some intellectual property identification and protection of it. And then you've got the companies at the far end where, when they start looking at a potential private equity investment and they get that email that says, send us your IP schedule, they attach it and return it. And we're going to talk a little bit today about how to identify and put together an intellectual property schedule so that you can, maybe not have a definitive value for each of the assets, but have it listed so that it's not zero and increase the value of your business.
Fantastic. Yeah. And as we have that story, or I'm sorry, that listing, et cetera, and we go forward with this conversation in the context of that company that's been around for maybe 20 or 30 years, they've grown organically and they've hit the American success story with just through their hard work, blood, sweat, and tears. And I've got a company worth millions of dollars. And maybe they haven't done that kind of a schedule. Maybe they haven't spoke with an attorney like you, and they just don't know what they don't know. So,
well, that's true. And I also think you've hit on something really important, and that is there's a lot of work in building a business. And, I've had my own practice, small law firm for 20 some years. And, there's the content of the business, and then there's the running of the business, regardless of what you're selling, whether they're goods and services. And a lot of business owners remember down at the cellular level the effort they put into that, but they maybe haven't tracked the other assets, the intellectual property assets that they've been developing with all that hard work.
Yeah. Okay, good. So you talked about in general what is intellectual property, and you mentioned that all businesses, they really have intellectual property, whether they realize it or not. But you also mentioned too, some of it might be the internal processes that they use. And I imagine most people wouldn't think of that when they think of intellectual property. Can you talk more about what that really means?
Sure. So, there's 5 different ways to protect your intellectual property. And one of the ways to protect them is through trade secret protection. And trade secrets have a legal definition. And the legal definition is that any business information that has independent economic value and that you try to keep secret. So if you're a manufacturing company and you have an internal specification for how your process runs, and the only people who know about that are the people on the line and maybe the engineers that run your line, then you're trying to keep it secret. You're not letting anybody else know what that process is. But on the other hand, it's also something that's very valuable to you, because if another competitor is going to try to make a similar product, they're going to have to start from scratch on their own process. And they would love to know your recipe and how you make this and what the wait time is and how much work in progress you have and all those different things. And so, the fact that you have a specified internal process, you can document it on your IP schedule of, specification, standard operating procedure, 1-10 or something like that. That's really valuable. And your competitors would like to know what that is. Maybe you're doing it better than they are. And so it has economic value. So trade secrets are one form of protection. And we'll get into a little bit more detail about that later on. I mentioned at the beginning that all businesses have a trademark because they have a company name. And we'll get into those details a little bit more too. So.
Wow. Well, this is going to be a good conversation here. So what are some of the common, you talk about processes, of course, trademark symbols and that. What are some of the common types of intellectual property? And maybe you can touch on what each of those are and just expand them a little bit so that business owner, again, who hasn't had someone like you that they've spoken with, who really understands this and all the details that come with, so they get a better sense of what they need to protect and how much value that really can add to the company.
So the good news about intellectual property is that it can be defined in just 5 different degrees. Okay, we have 5 ways of protecting intellectual property, and that's true for every company, and it's true in every country. Okay. So the 5 different ways are protected. The most common are trademarks, okay, because every company has them. And then we also have trade secret protection and contracts used to protect intellectual property. And then the other 2 are copyright and patent. So trademark and trade secret, contracts, copyright, and patent. Those are the five dimensions of intellectual property protection. I do want to throw a disclaimer out today. Of each of those 5 things, I give day-long seminars. And so, we have a relatively short time on the podcast. So this is the tip of the iceberg on those things. And so you're not getting your listeners aren't getting the whole picture. And so if there's something that piques their interest, I highly recommend that they do some more research on it, talk to an expert in the field, and see if there's something that they should be doing or should have done, or maybe shouldn't and haven't done, that they can do to protect that intellectual property.
Okay, perfect.
Okay, so the form of intellectual property that every business has is a trademark. And the trademark is the same thing as your brand, okay? Trademark is an umbrella term for those indicators of your brand, whether it be a word, a logo, a tagline, maybe even the way you package your goods that's really unique, okay? So a trademark is a brand that indicates to consumers who they're getting these from, who's making them, right? Who's the manufacturer that I can go to and be assured that I'm getting the quality that I want out of this. And trademark protection is interesting and neat in one way, in that you start accruing trademark rights as soon as you use a trademark in practice, okay, in commerce. So you don't have to register it. You can register it, and there are benefits to that. But trademark rights start accruing as soon as you start using your trademark in commerce. And the trademark rights accrue only for the geographic area where you're offering your goods and services for sale. And the internet, of course, complicates that, because most businesses have a website, and the website is global as soon as it's launched. But the trademark rights that are common law rights, that is, trademark rights that aren't registered, are really limited to a geographic area. And trademark rights, as soon as you start using them, you start accruing the rights. And that's important, because if someone else later on down the road uses a similar trademark for similar products as yours, if they're in a different part of the country, who's got the senior rights to that? Well, the first user does. And so it's, we say file early and file often on your trademarks, because whoever uses it first is the one that's going to have the senior right and can stop the other user. So you don't have to register your trademarks, but it's strongly recommended. And federal trademark registration gives you benefits that a single registration in a state won't give you, because once you register federally, you are deemed to have used your trademark in every spot in the nation, and therefore you have complete federal trademark rights that cover the entire country. Yeah, it's really neat. And you can register your trademark federally if it meets a whole bunch of criteria, but the main one is it can't be likely to be confused with another person's registered trademark. So one of the reasons to register your trademark is so that when the trademark examining attorney looks at the federal trademark database, they see that your mark is already there. Because you might be using it in Arizona, but if you haven't registered it and someone else tries to register a similar trademark, the trademark examining attorney won't know your trademark even exists, because they don't look anywhere but in the federal register to see if you can register your trademark. You can also register your trademark in every state independently, and there's very little value in that. And the reason is, there's many reasons, but the main reason is that every state's standards for registering a trademark is different. And none of the states use the rigorous federal standards for likelihood of confusion and how to register your mark. And in Arizona, for example, they let you register your trademark if it's distinguishable from someone else's. So if you have a word, Acme, and you spell your trademark ACME, and the next guy spells it ACMI for the exact same goods and services, the state of Arizona is likely to let you register that. But of course, they sound identical, Acme and Acme. And the federal register wouldn't allow you to do that. So you have broader protection if you get federal registration than if you're registering in the state.
Okay. Wow. So you said that the 5 criteria, or the 5 types, you said that isn't just the USA, it's other countries as well.
That's right. Intellectual property is recognized by every country in the world, and it's stronger in some dimensions in some countries than in other countries. The U.S. is considered to have very strong intellectual property protection. China, on the other hand, does not. And China's getting much better. They're being pulled into the global commerce and getting better at their intellectual property rights because they're being forced to. And typically, a Chinese trademark registration might be good if an American company is selling into China. Patents, not so much. But there are treaties that China is participating in to try to kind of level up their intellectual property protection. Australia has very strong intellectual property protection. Europe does. The EU, as well as now the UK out on its own. And some Asian countries have very strong intellectual property protection. So, the countries I've just mentioned, of course, are all first world, high commerce, industrialized countries. And that's typically where you go if you want to protect your intellectual property in foreign countries. You look at where are you going to sell it and where are you going to make it. And intellectual property protection is not a global thing. You have to register it in each country that you want to protect it in, which can get pretty pricey. But if you're selling in every country, maybe you have the revenue to support registering in every country.
Yeah. So I've spoken with some business owners before who've intentionally not patented some information because what they've told me is they don't want to patent it and then put it out there. They'd rather keep it a secret, keep it close to the chest, basically, because they're afraid that by patenting it, it tells competition, what they really have and how they do it. And they don't want to disclose that.
Right. And they don't have to. And so the trade secret, as I said, this valuable information, what their invention is, they can keep it secret. And as long as they keep it secret, no one's going to know about it. And so no one can use it. The value of a patent and the trade-off with a patent is, yes, if you get a patent, you have to disclose it, but then you don't have to worry about keeping it secret. What a patent does is it gives the owner of the invention of the patent the right to exclude anybody from making, using, selling, or importing, whatever that is. If you have a trade secret and someone else comes up with it after you came up with it and starts making it, you don't have any way to enforce to keep them from making it because they came up with it. Okay. Now they're not going to be able to patent it out from under you, but you can't stop them. Whereas if you had made that trade-off and disclosed what your invention was, then you can enforce your patent against a later developer and, either get them to stop so they don't take market share or tell them they have to take a license and pay you a royalty for each piece of whatever you made that they sell or an annual fee for the process. So, yeah. You can do that, and it's a very valid way to go about it if you're conscious that you're conscientiously not getting a patent because you want to keep it a trade secret, as opposed to, oops.
So a question I have for you that I remember hearing years ago, a long time ago, that the two people who knew the Coca-Cola recipe were never in the same room, never together, because that's how they kept the recipe secret. And I don't know if that's true or not, but it sure sounded interesting anyway.
Well, so I do a lot of work where I go into companies and I implement a trade secret program. And, the first thing we do is we get all the employees to sign confidentiality agreements. And we do brown bag luncheons and explain why it's important to keep this information confidential. And, there's everything from the legal side that I just mentioned, as well as, if I walk in and there's no receptionist, there's no locked door, and I can walk straight into the manufacturing facility, you're going to lose your trade secrets yesterday, right? If the contracts with the suppliers don't say that they can't tell when the deliveries are made or what the prices are or when the prices change, then you're going to lose it's not going to be what your manufacturing process isn't going to be secret, and you're going to lose trade secret protection. So in these programs, I look at everything from the physical plant and how it's being protected. Are the doors locked? Are the garage doors left open so strangers can walk in? I mean, I've seen the entire spectrum of what it is. We put up signs that say, loose lips sink ships. We give, it's a very combination of legal, practical, and education to get companies to be able to protect their trade secrets well.
Wow. It's amazing. So you
It's fun.
mentioned,
You're laughing. It's really fun. Before I was a lawyer, I was an engineer on a manufacturing facility in the semiconductor industry. And so, before I even knew as a lawyer what the legal ramifications were of trade secrets, I was educated at this global company about it. And I've been able to use that information from many years ago, we'll just leave it as many, and implement it. And clients are really happy to see that I have that practical knowledge.
yeah, I can see how that'd be very beneficial. You've got hands-on from the company's perspective versus now you're the attorney with the expertise. Okay. So you also mentioned contracts as well as one of those 5 items.
Yeah, so for protecting trade secrets, again, it's economic information that has economic value to the business that they use reasonable efforts to keep secret. Well, what's a reasonable effort to keep it secret? Well, the first thing is anyone who's exposed to that secret needs to be under a non-disclosure, otherwise known as a confidentiality agreement.
Thinking of exiting your business? This may be your once-in-a-lifetime opportunity to preserve your American success story. I invite you to come to the Scottsdale Founders Forum, a biannual live event for the founder considering exiting in the next 5 years. More information at scottsdalefoundersforum.com.
So here, a contract is helping you protect your intellectual property. In a company, you might have other forms of contracts that also help you protect your intellectual property. One of the ones that every company needs to have, but unfortunately many companies don't have, and that is an intellectual property assignment. It's a simple agreement, literally often one page, that says, I, Mr. Employee, agree to assign, and hereby assign, that means transfer all my intellectual property rights to the company. And people think, well, I pay him, I own it, right? Unfortunately, that's not how the law works, okay? Specifically for copyrights and patents, if you don't have some sort of written indication that the person who came up with these things has assigned the rights to the company, then there's a basis for the employee to make the argument that they haven't assigned it and then they own it. And then you can get into this, weird situation where you have this employee that wants something more than just to be paid for the information. So with an IP assignment and a confidentiality agreement, we recommend that when a company starts a new employee, that those are 2 of the agreements that they have their employees sign. And with respect to IP assignments, the good news is if you didn't do that as a business owner with your employees, you can make assignments retroactive.
Oh.
So yeah, so that's a kind of a safety net. So for business owners who haven't done any sort of IP assignment and they have some intellectual property that some employee in their company or even an independent contractor, but let's for this sake stick with employees. If they haven't assigned those rights, you can go to them and ask them to assign the rights to the company. So some employers say, oh, I'm not worried about it. It's in my employee handbook. Well, that's better than nothing. But unfortunately, it's not always enforceable because you want to have something in writing. And if it's just an employee handbook that's, given out every now and then or kept in the HR office or on the president's desk or maybe online with some secret link, then you don't have any evidence that the person, the employee, agreed to these things. So some companies take the additional step of having their employees sign the handbook, and that's fine too. But you know what? It's really simple to have a non-disclosure agreement and an IP assignment and have the employees sign each of them, regardless of what's in the handbook.
Okay, so Sandra, that swoosh that Nike has,
yeah,
I thought I read somewhere that was developed by one of their employees.
Mm-hmm.
So if they did not have that kind of an agreement and Nike began to use it on their shoes and it became their global brand, if they did not have something like that, then they might end up in a fight with their own employee or maybe ex-employee that he or she claims some rights or some economic damages because they didn't get paid for that or they own it.
Yeah, well, so if you're a person inside Nike and your job is marketing and your job is to come up with a logo, okay, then you're hired specifically for that purpose, and what are you going to do with the copy? You don't own the trademark because the trademark travels with the shoes, okay, with the goods. But you're going to be a marketing person and you're going to say, well, I own the copyright in that swoosh. Well, I don't want to go off the ledge, tip deep into copyright stuff, but there's it's questionable about whether it's even copyrightable because it's so simple. The answer is probably yes. And you get a very practical question of why would a marketing person at Nike, decide that they're going to claim that that's their work? I mean, they're going to lose their job. They're going to probably lose in court, and any attorney is going to tell them that. So the Nike swoosh is an example that doesn't fit squarely in our hour of explaining why. I wouldn't be too worried about that. On the other hand, why not have your marketing people who are designing logos under an IP assignment?
Yeah. So
right?
the cleanest, simplest thing is get those agreements done. And as you said, maybe you didn't do this on day one, and maybe you're already 20 years into your company, but you can make those retroactive and get those done now.
That's right. I will say, if you're not working with an employee, if you're working with an outside designer, okay, let's say you've hired someone to develop your website or renew your website, right? Completely overhaul it. Well, now you're talking not just using your logo that you already had existing, but you're talking about adding maybe new logos, developing the text, the content for it, how the pages are laid out, what colors you're using, the look and feel of it. And yeah, you're paying this marketing company to do that, but let me say, they're in the business of creating websites, so why would they want to retain the copyright to your website? And there's reasons for that, but nonetheless, you should say to them, hey, I want you to assign the rights to this, or I want you to say in writing that it's what we call a work for hire. And work for hire, when we talk a little bit about copyright, and I'll go into that in a minute, copyright protects, allows you to keep people from copying your works verbatim or nearly verbatim, okay? And it's relatively thin protection, but it lasts forever, so it's nice to have. So when you go, talking about copyright, there's so much misinformation on the internet about it. Copyrights and patents are the most misunderstood of the forms of intellectual property protection. But if some people will say, well, it was a work for hire and therefore I own it. But the statute for the work for hire statute, the federal statute, says that you have to have the work for hire in writing. So when you have a company design your website, you want to have a written contract that says that they assign the rights to you and or it's a work for hire, and have it in writing. And that way they don't own any of your website. You own the copyright in your website.
Yeah. And I can see, Sandra, how people might not even think about that, because you're hiring a company to develop things creatively for you. You're paying them for their services, and you might just assume that since they did it, you paid them, and now you've got a beautiful website that does all the functions that you want, that it's yours. You bought it, you paid for it.
That's the big thing. I paid for it. It's mine. Well, no, you paid them for their services, their time that they put into it. Okay. Wow. And so that's a big misperception. So a business owner wants to be sure that it has in writing that it owns the intangible rights to whatever the website developer is creating. Same with if you have a software developer that's creating a proprietary mobile app or some sort of SaaS system, a software developer is going to want to be able to reuse certain portions of the software because it's common to every program that they write for every company, which is fine. You don't need to own that, but you do need to own the copyright in the universal product. And so you want to have an assignment from your software developer that either they assign the rights to you or it's a work for hire. I see both in contracts, to the extent that it's not a work for hire, I assign the rights, get all that legal words in there to make sure every aspect of it is covered. So, and copyright is interesting because copyright protection attaches to the underlying work as soon as the work is created and put into a tangible form, either a piece of paper or a hard drive, for example, or a canvas, or some sort of silk screening on a shirt. As soon as it's put into something tangible, the copyright exists. and you don't have to register a copyright to own it. But again, there are benefits to registering the copyright. It's really inexpensive to do. You can do it online. The main benefit of registering the copyright is that in order to sue for infringement of copyright, you have to have it registered before you file the lawsuit. So it takes some time to register, a few months maybe, but why not have that copyright registration listed? People that are interested in your company can go to your website and see that you've registered the copyright in this proprietary product, or if you're a publisher, the books that you put out, and it's registered. You can see that publicly the registration is available. They're not going to see all the code, so it's not like you're giving that up. But it's there's value to having certain creative works registered, and since it's relatively inexpensive to do, there's not much reason not to.
So Sandra, when I think about copyrights, I think about that little symbol with the circle and the C in the middle.
Yes.
On say an article that somebody might write. In my mind, that's what a copyright is. But
that's the copyright notice, and
it sounds like it's not isolated just to printed or written material. It's much broader than that, from what you're describing.
Right. But let me go back to the notice. Okay. So if you think you own the copyright in something, whether it's registered or not, you can put the copyright notice on it. I mean, it has to be a bona fide belief that you own the copyright in it, and you put the circle C, as we call it, followed by the year of publication. So if you were publishing something this year, it's circle C 2023, and whoever owns it, Acme Engineering, or if it's you personally, Armando Roman. I mean, there's all these, whoever owns the copyright puts that in the copyright notice, and you can put it on anything. But copyright extends not just to text, it extends to any creative expression. So, sculpture, for example, is protected by copyright. Some artistic designs on useful articles are protected by copyright. You have the text, literary text, as well as software code, movies, music, not only the tune, but the lyrics. If you're a band and you write your own song, you write your own lyrics, and then you perform it and you record that performance, then the performance is protected by copyright. And copyright gets really complicated really fast, but for businesses that aren't creating goods, the stuff they sell isn't the creative aspect of it, but instead they use other people to promote whatever their goods and services are. There's still stuff to be protected by copyright, and you're going to want to use the copyright notice at least on your website. Use it on your marketing materials for trade shows, internal standard operating procedures. Those types of things should show the copyright notice.
Wow. There's a lot more than I realized in this whole intellectual property space.
Well, but it's not your job to be an expert in it. It's not the business owner's job to be an expert in it. They just, we have to educate people what the basics are, the 5 ways of intellectual property protection. And I'm telling you, once a business owner can walk through those 5, the light bulb goes on, and can really start listing what potentially might be intellectual property. And I highly recommend that business owners do that. They list it.
And so those 5 again, you said trademarks, contracts, trade secrets, copyrights, and patents.
That's right. And we've touched on trademark and contracts and trade secrets and copyright. And so I want to touch a little bit more on patents.
Perfect.
Unlike copyrights that exist when it's fixed in a tangible medium, or trademark rights that start when you start using the trademark, patent rights don't exist until you actually have an issued patent. Okay, so there's a whole bunch of criteria involved in getting a patent, but the process basically is you invent something, you file a patent application, and you can claim patent pending, but you have no protection until a patent actually issues. And that patent application has to be filed within a year of when the invention has been made public or offered for sale. And that time bar trips up a lot of businesses, because a lot of businesses think, well, patents are relatively expensive. You know, you're going to spend 10, maybe 15, $20,000 to get a patent over the long haul of the process. And so I'm going to wait till I'm selling stuff, getting revenue and getting profit before I file a patent application. Well, you know, it often takes more than a year to make a product successful. And so by then it's too late to file the patent application. So there needs to be a strategic mindset of, you know, when do I file a patent application? Do I really want to wait for revenue profit on it before I file, or do I want to file it now and hope that I can recoup that money? So that 1 year time frame is really important for companies to know. Now, that 1 year grace period only exists in the US. It exists in no other countries. So if you want to patent something in Germany, you have to file a patent application, at least in the US or in Germany, but you have to file a patent application somewhere in the world before you offer it for sale in Germany. Otherwise, you lose your rights.
Wow.
And the main criteria for getting a patent on an invention is that it can't be obvious in light of other publications, other patents, other products on the market, which we collectively call prior art. Your invention can't be obvious in light of prior art that was published before the filing date of your patent application. So, you know, once you file it, if some competitor comes out with a competing product, they're not going to keep you from getting a patent because they published after you filed your patent application, right? And it can't be used to defeat the patentability of your invention. So, you know, a common way to get the common process for getting a patent is that you talk with your patent attorney and kind of have your ducks in a row presenting what the invention is. You might have a sketch, whether it's literally a hand sketch or CAD drawings, and you explain to your patent attorney what the invention is. And just so people know, you can't be a registered patent attorney unless you have a science or engineering degree and a law degree. Okay, so yeah, so and there are patent agents. They don't have the law degree, but they do have the science or engineering degree. But to be a registered patent attorney, you have to have both. So when a tech company comes in and describes an invention to me, you know, the business owner has to recognize that although I'm not an expert in their technology, I'm a technical person, okay? And to the extent that they can show me a drawing of it or show me the formula for it or, you know, a written description of it, maybe even a photograph of it, I'm going to understand that invention. And what I don't understand at the technical level, I'm going to ask them about. They're the expert, okay? And they're going to explain it to me.
Yeah.
And so, you know, patent attorneys do that on a regular basis. And you can get patents in you know, nearly every form of technology, you know, biology, mechanical, most invention patents are on mechanical inventions, chemical inventions, electrical, software, applications of machine learning and AI, you know, all those things are potentially patentable if they can get over this many criteria, but the big hurdle is the obviousness one. So let's say a company comes to me and says, I think I want to patent this. Well, you know, we can do a patent search, but patent applications are confidential for at least 18 months. So if this company is coming to me with something that's on the cutting edge, a patent search isn't going to do us much good because I can't look into that 18-month confidential window and even see what else has been filed, right? But we might do it just to get the state of the art. So let's say we do a state of the art search. Looks good, okay? We're not seeing anything that's going to defeat the patentability of the invention. We file the patent application. If you pay the regular filing fee, your application will be reviewed somewhere between, you know, 1.5 years and 3 years from now. Well, that's a long time to wait. So a few years ago, the patent office allowed you to pay an expedite fee. It's several $1,000s, but, you know, again, you know, my firm represents privately held businesses, small to medium size. And I would say almost all of the patent applications we filed are filed with this expedite fee paid to the patent office, because then you get review within 4 months and you'll know right then and there whether or not, you know, have a good idea of whether you're going to get a patent or not. And so instead of waiting 3 years, you find out in 4 months, and then, you know, the whole process is accelerated. So let's say your first examination looks good and you can probably get a patent. You're going to have a patent within a year, and you may not even have the product ready to go on the market yet. But once it goes on the market, right, anybody that wants to copy you is out of luck because you have the patent on it. And if they were to copy it, they would be infringing, and, you know, you stop them from infringing. Typically, it starts with a cease and desist letter. If they don't comply, then you can file a lawsuit. Typically, a cease and desist letter, if you can show that their product is infringing your patent, the settlement won't happen at that level. You won't have to file a lawsuit typically.
Wow.
So one more thing. So as I mentioned, during that patent pending period, you don't have any protection. Okay. And that's another misconception. Patent pending doesn't mean patented. It means you file the patent application and that's it. You don't have protection until a patent issues. Once a patent issues, your patent protection lasts for 20 years from the date you filed your patent application. Okay. So, you want to get to the, am I going to get a patent part sooner than later so that your patent protection lasts more of that 20 years than if you waited and waited and waited for your first examination.
So if you did the regular filing and it took 3 years to actually get it, you would already have used 3 of the 20 years.
Right.
Wow. Sounds like the money is worth it to expedite.
Well, it is. And let me, we talked a little bit about foreign patent protection. So there's been great effort in the past 30 years, maybe 40 years, that the leading industrial countries have tried to set up trade agreements so that the laws and the processes of how to get a patent are harmonized. And it's not there yet. We don't have one global system for patents. Every country has different laws. And so the way it works right now, I'm only licensed in the US, but I have colleagues in over 70 countries, patent attorney colleagues in over 70 countries. And it's beautiful. They all speak English. It's wonderful. And so, if I have a client that files in the US and decides that they also want to protect in Canada and the UK or the EU or South Korea, then, I just send an email to my colleague and say, can you file a patent application in your country for this guy, this business? So it's, it's a global business, even though each patent is territorial to the country. Each country has its own laws, but I like my job. It's wonderful. I get to meet really interesting people from all over the world in the patent community.
Well, I hope you get to visit with them once in a while in their home countries when you're on vacation or otherwise.
I do. And yeah, it's great. It's very nice. They're all very nice. I have, friendship relationships with attorneys in mostly English-speaking countries, Canada and Australia and Singapore, where, English is the native language. I'm monolingual, so I don't understand Japanese and Korean, but they speak English just fine. So yeah, it's wonderful.
Wow, good. So, Sandra, what are some of the common mistakes that you see with intellectual property that business owners make?
Well, not to harp on it, but many businesses, the main mistake is they don't identify their intellectual property. And if they don't identify it, they can't protect it. So the main mistake is main thing to avoid is not recognizing, not identifying what your intellectual property is.
So Sandra, if you could talk a little bit about that, not to interrupt, but I'm just thinking now of that once in a lifetime sale that many business owners go through. And you don't want to have hiccups when you're in that, in the home stretch selling the business. You want to address those things well in advance so that when it is time to actually sell or transition to the next owner, that it's a nice, smooth process, well thought out. So if they haven't identified and now they're actually, it's game on, they're selling, they have a buyer, they've agreed on things, there's an LOI, and now they're going forward, and then they bring you on board. How does that, when you come in and they haven't met with you before, how does that work?
So, as I mentioned, I represent privately held businesses from cradle to exit. Yeah. And the ones that I've represented from cradle, many of them are still with me after 25 years, which is just a wonderful experience. And so, those people, if they're looking to exit, they'll email me and say, can you give me an updated IP schedule, right? And then I have the people that I've never met before in my entire life. They have a 20 or 30-year-old business. They're making, revenue 20, 50, 70 million a year, and they're looking to exit either because of retirement or because the market's right for it. And they start talking with corporate counsel or, a business M&A person. Typically, they don't get to the stage of a letter of intent before we figure out that they don't have an intellectual property schedule. So they'll go to a corporate counsel and say, I want to sell my business. They'll go to their CPA and say, I want to sell my business. And that expert says, all right, we need to get, financials in a row. We need to get your IP schedule in a row. We need to do this and this. And that's when the question comes up, what's your IP? And then they get a hold of me and I can do what's we call in the business an intellectual property audit. It sounds very formal and official, but it's not. It's questions and answers of, do you have trademarks? Let me see your website. What domain names do you have that's not just acme.com? Did you register acme.biz, acme.org, acme.net? Which is putting a picket fence around your domain names to make sure other people don't register it.
Yeah.
What contracts do you have with your suppliers? Are they exclusive contracts? Are they limited in duration? Do you have any licenses to other third-party rights? For example, if you're a company that is commercializing R&D, you might have a contract with U of A's technology transfer office that gives you the right to U of A's patents exclusively for a limited period of time. So you don't own the patents, you don't own the technology, but you're the only one that has a license to it. And again, people don't think of contracts as corralling their intellectual property, but that's a very valuable thing. So we go through a question and answer period to do this audit, and I can start putting together the IP schedule. And then once we do that, we figure out, is there anything that needs to be protected? Is there anything that we can protect at this point? And I would say for the people that come to me that really weren't aware of intellectual property before they thought they were going to sell, the main thing that we do is we file for trademark protection. And we'll do a trademark search at that point because, again, businesses may have been using their trademark for 25 years, but it never got on the Federal Register. And there may be other registrations on the Federal Register that would block their registration, even though they're a senior user. And then we have to analyze whether it's worth it to stop everybody else or just call it good. And because, clearly if there's interest in your company, the person or the business that has interest maybe hasn't done any due diligence yet, but there's some value in their company, whether or not you have intellectual property. So, we try to bolster the value of the company by having really a formal intellectual property schedule, so that we can show how the competitive edge is going to last once that founder's gone, right?
Okay. So I spoke with the merger and acquisition attorney last week, and she told me, the M&A attorney, of course, is the one who gets involved with a sale of a company. And what she told me, and she's with the regional firm that has several offices across the country, but she told me that when she gets involved, typically 95% of the time, it's when the company owner already has an LOI or has already agreed to a price. They already found the buyer. And so she gets pulled in to kind of, okay, it's time now. We're selling now. Here's the buyer. Here's the price. Help us get this done.
Yeah, get the paperwork done.
Exactly. So she would love to have the luxury of being engaged well in advance to help her owner, the seller of the business, help them solidify things, get that IP audit done, bring you in to get the audit done. But that just isn't how her world works. And I imagine
I'm surprised at the 95% level because, nobody goes into business to be in stasis mode. They go into business to make money, right? And so, if a client's been with me 20 years and they haven't exited, it's because they didn't want to, right? They've had their ups and downs, but after 20 years, they're not struggling. Otherwise, they'd be doing something different. Yeah. And so, by the time you've got 20 years under your belt with the business, you're very independent. You're going to go find your buyer. But so my experience is opposite, just due to the nature of my clients. These people the vast majority have come to me earlier in their business. So for the people that don't have an IP schedule and they get an LOI, realistically, I think it's still good to put an IP schedule together, but and I'm not sure you're going to lose the deal, because again, the buyer found some value in your company without an IP schedule, right?
Yeah.
On the other hand, maybe you can get a higher value,
right,
if you then provide an IP schedule.
right.
So, it's never too late. File early, file often, schedule early, schedule often. It'd be my grand hope that every business school in the world teaches their students that are in business and entrepreneurship about intellectual property. And I speak occasionally at, I used to speak when Thunderbird was its own grad school, and now, within ASU, and I speak to intellectual property there. I've spoken at the community colleges about intellectual property, particularly to the design students, because, creative people are often not real big on doing things right from the beginning legally, right? Because we're all good here. Everybody feels good. It's a touchy-feely community.
Right.
But I can tell you that, my son's colleagues that are, of college age, they don't know anything about this, and they're in business school. So if they're going to go start a business, the only way they're going to learn it is if they know to go teach themselves, or they start out with some other employer, right? And that employer teaches them the value of trade secrets and inventions and patenting and that kind of stuff. So, any education I can spread about this, I'm happy to do that.
So you've mentioned IP schedule several times. Talk about, if you would, what is that?
It's a list. It is like a chart of accounts for QuickBooks. It's a list of, what are my trademarks? My company name, my product name, my tagline, my logo. What are my contracts? Well, I've got the contract for the license to the domain name, and then list all your domain names. Copyright. Do I have anything that could be protected by copyright? Well, my website content, my proprietary mobile app, my SaaS applications. Maybe you have some sort of internal process that you've put on, your HR. You didn't like the commercial vendors for the software, so you did your own homegrown version, right? And then, your trade secrets. You don't actually list your trade secret. You wouldn't. Coke doesn't write down the formula on its IP schedule, but it does say the formula for Coca-Cola. Okay, so you're going to say what your trade secret is. Again, is it, my standard operating procedure 1-10? Is it my HR procedure, my HR handbook? I mean, you can list all those things. And then, of course, your patents, if you have any. And maybe you get to patents and you realize you don't have any patents, but you've got new products on the drawing board and you think they might be patentable. Then list them. Say the new spinal implant with the, articulated tip, right? Or whatever's on your drawing board. If you can list those, whether they're patented or not, those inventions, then, maybe you can get some patent applications on file before, the letter of intent and the value is determined.
So I do have a question.
It's just a list, just a table.
But so it's a schedule of all the intellectual property that belongs to that company.
That's right.
Okay. So a question for you, getting back to patents. I spoke with a business owner recently who said just exactly what you said, Sandra. They said that they've got all the things they've invented that they have not patented because the cost. It's just too expensive. There's not enough revenue at this point to do those patents on each of those inventions. What I didn't realize till this conversation with you is that after 12 months of, is it 12 months of invention or 12 months of getting that onto the market? Which one is it?
It's making it public. And making it public, you can do in a number of different ways. Typically, it's offering it for sale, even if it's not in boxes on the Morehouse deck ready to go out, right? But if you offer it for sale, or if you've publicly disclosed it, for example, medical device companies will send out press releases saying, we have this new orthopedic implant available for sale October 2023. Well, they just made it public. And so that's when the 1-year time clock starts. So, and it can be, there's Supreme Court cases on when that clock is triggered. And so, I get calls every now and then, multiple times a year, saying, we have a trade show starting Friday, and we've got all these banners up about this product, but we didn't file a patent application yet, right? And so, patent applications are relatively complicated documents. And, every now and then I'm up really late at night getting this thing on file before the date of the trade show so that we can never have that argument that we disclosed it at the trade show, because we want to file for patent protection not only in the US, but other countries potentially. So.
Wow. So from a marketing perspective, I can see why companies would want to make an announcement well in advance. Hey, coming fall of 2023. But if that makes it public, then the downside of that could be is they're starting that clock ticking sooner than they really probably want to.
Yeah, and so the size of a company's patent portfolio often grows with revenue, and we put in an invention disclosure or a patent disclosure program so that once we have one patent application and the business owner sees how the process works, then they can educate the people in their company that are doing the inventing, and the inventors will go to their boss or go to the patent team and say, here's a paragraph description and a hand sketch of what I think is going to be our next product. Is this patentable? And then you kind of get the ball rolling so that after 20 years you'll have 3 or 30 or 300 patents that were all, the patent applications were all filed before the product ever went on the market. So another aspect of that, some companies say, well, this is a really cool thing, it's a really neat invention, but it relates more to, again, going back to medical devices, it relates more to back surgery than knee surgery. It's just that in our discussions, this came up. Well, let's say you're in the business of orthopedic implants for knees, okay? You can still get a patent on a spinal implant, but maybe then you sell that off, right? You recoup the money that you put into it, or you license it and you recoup the revenue that you put into it, and you use it, to expand the scope of your business. And then if it gets to where you're putting too much effort into that, then you just sell it off, but you collect money for it. So it's a source of revenue that's not your main product revenue.
Yeah, I'm so glad you brought that up, because even though it might be outside the scope or their normal scope of business, it could still have some kind of economic value.
Oh, yes.
You can help them lock that down with a patent or otherwise, and they could sell that off or license it and generate some revenue from it. So it's not necessarily a dead end or a lost endeavor.
Oh, no.
But it's recognizing that it does have or could have some economic value for the company.
So there's another interesting thing that you see companies that have a lot of patents or have a lot of invention, and they talk about what is the patent landscape for our products, okay? And I could go spend an hour on how patents cycle, invention cycles, and so if you have a certain widget, everyone and their brother will be inventing on it, and then they'll sell and maybe lose popularity in the marketplace, and then a decade later that invention number of patents filed on that may increase again. And so what a business can do is they look at not only what their patents are, but what their competitors' patents are, and they can see gaps, and they can file patent applications in that gap to expand their scope of protection, but moreover prohibit competitors from getting into that space, which narrows the competitor's scope. So it can get, determining the patent landscape can get really sophisticated really fast. And if you are a company that is focused on invention, then that's something that you want to look at. If you're a company that is not technological, that doesn't have patents, many businesses are multi-million-dollar businesses that don't have any patents at all. It's really a narrow slice of the market that has patents. But if you're in a technology field, then you really want to consider that.
Wow. So some of the, if you look at just, say the last 12 months of what you've been working on, what are some of the common things that you keep, maybe not for a client you've had for 20 years, but say a new client comes on board? What are some of the surprises as you're talking with them that they're the deer in the headlights look because you've helped them understand?
So this is going to sound so trite, but it is such a valuable question. I asked the business owner, what's cool about what you're doing? And every business owner lights up and says, this is what's really cool. We're doing this and this and this. And somewhere in that cool scheme, there's something that's protectable with intellectual property. And
Oh,
yeah, and when I implement invention disclosure programs, invention protection programs within companies, that's one of the early questions is, what's cool about this? What's neat about this? When you came up with this, who did you tell first and why, right? Because more than likely you told your colleague and they went, I never thought of that. Boom. Something that's new and different, potentially patentable, protectable, and so on.
that's funny. It's such a simple question. Almost sounds like, hey, what would you like to brag about? But
Yeah,
it takes them right where you want them to go, and they start talking about that thing that makes them different or unique.
right.
Huh.
Yeah, what's cool? What are you doing that's cool these days?
Wow. Interesting. That really makes it so simple. What have some of your surprises been when you've asked that question and they've responded back to you? What are some of the things that you remember that were just maybe unusual or different?
Well, because of client confidentiality, I can't answer that in specific, but I can answer it, generally, and that is I get kind of two responses. I get the bright-eyed, oh, well, let me tell you, what makes this cool is because of this new spout we have on this bag, we can put it into everybody else's just drink dispenser, right? Well, that's really cool. They're thinking of it from a market scope standpoint, and I'm thinking, wow, a universal connector, potentially patentable. And then you get the other folks that say, well, everything we do is really neat. I love my business, but we don't have any intellectual property. I mean, it's still that modest.
Yeah.
If I can do it, anybody can do it, right?
Right.
And so that takes a little more teeth pulling on my part to extract the information from them.
Right. And but that seems to be very, very, very common for business owners. They've been doing it for so long. And to them, it's become common knowledge. Everyone should do this because I'm not that brilliant, and yet we do it and do it really well. So I don't know if it's more modesty or more of that it's happened with them over time in little bits and pieces.
I think that's part of it. I think you're right. I do. Yeah.
So yeah, interesting then. Huh. So anything, Sandra, that we haven't touched on in this conversation? The person this is intended for is they've had their company maybe 20, 30 years. They built a really great company from very humble, very modest beginnings. And now this company has substantial value. And at some point they realize, as we all do, every person has an expiration date. And if that company is going to live beyond the owners of the business, they've got to actively transition that company to someone else, or when you die, it will happen without your active involvement at a much lesser value for your family. So what have we not touched on in this conversation that's really within that whole intellectual property space that might be worth touching on for that particular business owner?
Well, I'm happy to say I think you asked all the right questions, and I think that we there's nothing glaring that has been omitted today. The only thing we haven't touched on, I guess, that I would recommend is that the business owners didn't get to where they are alone. Okay, they have a CPA, they have a financial advisor, they have a corporate attorney. Yep. They may be involved in YEO or YPO, and they have business colleagues. It's time to tap those people and say, what am I missing? And, sometimes I've seen this particular with attorneys. The client sees their attorney in a pigeonhole. That's my corporate attorney. They don't know anything about intellectual property. Well, part of what attorneys do is they counsel businesses outside of just let me document that merger and acquisition. Okay. And they say, go to your corporate counsel and say, I'm thinking of selling. What do I need to consider? Go to your CPA and ask that same question, and give that counselor the permission to finally tell you what they've wanted to tell you for 20 years, but they knew you'd resist. Okay. and get their advice. And then, just to recap, you're running your business. Now you're going to take all the time to do the M&A. It's not like you have a lot of spare time, but it's worth it to put in the time to talk to your advisors, to do an intellectual property audit, write down what your assets are and any related information that you can think of. talk to your corporate counsel or your M&A counsel who's going to be documenting this, and talk with the IP counsel if it seems appropriate. And the best way to find an IP counsel is through a trusted resource. Either your CPA, financial advisor, corporate counsel, business colleagues, because they're going to understand your personality and your business, and they're going to say, I worked with 3 different people, and the one I would recommend to you is this.
Yeah.
And then once you put your IP schedule together, if there's things you can still protect, then let's file for registration.
So your IP schedule, it sounds to me from what you described that if a business owner does not have an IP schedule, they haven't created one, and they're going through, say, that exit, that transition, that sale process, they could be leaving quite a bit of value on the table. And for most people, at least here in Arizona, when they've had a business for, say, 30 years or so, this is their one and done. This is their once in a lifetime exit from the business. And it really needs to be done right. So whatever outcome that business owner wants, once it's all done, that they get as close to that place as possible. And for many of them, as we talk with business owners, what they say to us is that this is my once in a lifetime chance to get it right. I've got to get it right. And so part of why I'm glad that we can have this conversation, Sandra, is that in your space, with the expertise that you have, it can be extremely valuable for that business owner just to have a conversation with you, because they don't know. And your question, what's cool about your business or what's cool about what you do, it will help bring up how you can help lock in that value for them.
Right. And on that note, okay, so I've represented hundreds and talked to thousands of founders literally over the years, right? And I have a system for how I question things. It's not formulaic, but in an hour of an initial consult, we can get a really good idea of what kind of intellectual property is there. We can't put the schedule together at that point. That takes a little bit longer. But yeah, within an hour. And most intellectual property attorneys don't charge a consult fee for that first hour. Some do. We don't. But it doesn't take much time. You got all this other plates in the air with a potential sale. Can you spare an hour, friend? I mean, it's really, that will give a business owner a good idea of whether there's something to spend more time on or just let it go.
Yeah, good. So I'm just going to recap just kind of quickly here. We talked about intellectual property in a very, very broad sense. You said there are pretty much 5 main areas of intellectual property: trademarks, contracts, trade secrets, copyrights, and patents. We touched on what each of those are. We talked about some of the common mistakes that related to intellectual property. You mentioned an IP schedule several times, and basically that's a listing of what intellectual property does your company have. And it might not just be the company name or the copyrighted materials. It might be a brand. It might be a process that they use that maybe a competitor doesn't have. So there are lots of things in there that fall into the intellectual property space. You talked about an IP assignment, making sure that the company's employees have a signed IP assignment. So whatever is created while you're paying them to work for the company, that it's clear that creation belongs to the company. Right. And touched on that along with a confidentiality agreement, that whatever they're working on and whatever they're learning in the business, it stays in the company. They're confidential. They're bound by that confidentiality agreement. You also mentioned a work for hire agreement. So it just sounds to me that as people are going through, and if they have questions or doubts, they need to make sure to have a conversation with you or someone who knows your space so that they get the right guidance well before that exit. We talked about some of the common mistakes and about what owners can do to help, really rein in that intellectual property as well. And I like how you started. You said that really, intellectual property, it's intangible. It's intangible. It's there. It's worth. It has a value.
Yeah.
But
you can't touch it.
Right. Yeah. Right. And sometimes people forget what they can touch, so that it's lost that way. And then, so Sandra, let's say that a business owner is been hearing this conversation and they really want to talk with you and schedule time with you, what is the best way for them to reach you?
Best way to reach me is just to call me. And I can give you our office number, or people can find it on our website at ethertonlaw.com.
And what is your office number, please?
It's 602
Okay.
681 3331.
So 602-681-3331. And you said Etherton Law Group?
Ethertonlaw.com.
Ethertonlaw.com. Great.
Correct.
Sandra, any final things that we didn't touch on that you want to make sure that business owner hears while they've got you in front of them?
I am so excited and proud of business owners that have something to sell after 30 years. That's just awesome. So
it is. It's the American dream, American success story, and we're excited to work with them as well, because we get so many that walk in our door who very humble beginnings, and through blood, sweat, and tears, they've made their own American success story.
Yeah, that's great.
It's exciting.
Thank you again.
Now, Sandra, thank you so much. Really appreciate it. And let's hope that the right business owner has heard this conversation and will reach out to you with any questions.
All right. Thank you.
Great. Thank you. Thinking of exiting your business? You may have only one chance to get this sale right. Your family depends on it. Come hear experts who plan and negotiate successful business exits for a living. Bring your questions. Live panel discussion followed by Q&A. Join us at the next Scottsdale Founders Forum, a biannual live event for the founder considering exiting in the next 5 years. More information available at scottsdalefoundersforum.com.